Okay, so the Supreme Court has ruled.
What is it?
There's a 5-2 in favor of Afenyo. I'm told that Justices Stanko and Lovelace dissented.
Case closed.
Yes.
Okay. I hope
I love to read dissent.
Yes.
And because you raised the issue of dissent, Randy, I just want to read a very classic dissenting view by Justice Lord Atkins in the famous case of Liversidge versus Addison. Okay. And this is what Justice or Lord Atkin had to say.
It's an interesting case. Read it.
It's a very interesting. It's a groundbreaking. You know.
He was a liberal.
And that is what he said.
Yeah.
I view with apprehension the attitude of judges who, on a mere question of construction, when faced with claims involving the liberty of the subject, show themselves more executive-minded than the executive. They show themselves more executive-minded than even the executive. You see, Randy, we are building a constitutional democracy. A democracy that we are hopeful and confident will live.
So interestingly, the panel had the original 5.
So the original 5,
the 5
I think all went well on the injunction.
Sat on the injunction. Yeah. And then they added 2.
They stay.
They stay. So they added 2. The 2 were Justices Stanko and
so they dissented.
Lovelace. Yeah. So the 2 were added were those who dissented. The 5 who ruled in favor of the stay all ruled for Afenyo-Markin.
But let's not read things to it. I mean, we are just reading too much.
Oh, right.
It's quite
I have just made an announcement.
I know, but let me say, okay, I want to stop us from reading. But it's good.
No, the 5 that were, I don't want to say unanimous 5.
Okay.
The 5 that were unanimous in their decision on the stay. Yes, I mean, were unanimous. They were unanimous on their view on this. Yes. The 2 that were added
but as you know,
dissented.
Interim judgments are easier to obtain than substantive ones.
Okay.
You just have to show where the balance of convenience lies, isn't it? That's the test.
Randy, I think now that there is a judgment, we can fairly critique it.
Okay.
So I'll proceed.
But again, you the reasoning.
No. Hold on.
You are going to speculate.
Hold on.
Okay.
You see,
it lasted like half a minute.
Oh, okay.
No, they're just reading the verdict. Once they decide, then
I think usually such ones they'll go to conference and have conference. So usually you won't even get a judgment now immediately. It may take maybe a week or a few days to get it. But you see, I was on the Mo Ibrahim conversation when you introduced the breaking news. You see, when I first saw the Mo Ibrahim report on Ghana, first of all, it's a very credible platform, devoid of the NPP-NDC conversation. So when I saw it, I was apprehensive. Because for a long time, if you monitor the Afro-Barometer report on the workings of the courts, the reasoning and what Ghanaians have generally said about the court has always provided a cause for concern. For me, the height of it was when the National Security Minister, the Honorable Kandapara, a person who had had considerable working experience with Ghanaian institutions, had cause to tell the court or the judges in their face that when a particular consistent outcome is churned by the court, it has the potential of undermining one critical thing that is required in a democracy, public confidence. In fact, Randy, the only way you and I will have a dispute and would approach the court is that we believe at the end of the day we will abide by the outcome. But the very moment our confidence in the system of adjudication is compromised or undermined in any way, the next will be that we'll be resorting to self-help. And that self-help mechanism is a recipe for chaos. When I saw this Mo Ibrahim report, in fact, I even said, there should be an emergency judicial council meeting, at least to consider this urgent matter. Because you see, it goes to the very core of justice delivery. When an international organization, and remember, business people, when they want to invest in Ghana, what they do is to look out for such polls, to look out for such views from credible institutions. Now, if you're a business person and you are coming into the country, and you read from Mo Ibrahim or his report that the impartiality of the judicial system had moved from a record high by not a 1 percentage point, not 10 percentage point, not 20 percentage point, but 30 percentage point from 2017 to date. That should be worrying for everybody. In fact, if you practice from our court, if you're a judge and you are not worried by the Mo Ibrahim Index, its report on Ghana, then there is a problem. For us as lawyers, because we represent foreign clients, when they come, they'll ask you, do this due diligence for me, do A, B, C, D. If they are coming with a perception that our court is less, when it comes to partiality, it goes to the very core. And it even undermines inflow of investment. Because for a foreign investor, there's always a potential that you may have an issue.
In fact, even some of the recent cases at international arbitration,
yes,
that have traveled through our courts, even fortifies this position. The rulings of our courts on some of these cases that eventually ended up at arbitration, and the result from arbitration even fortifies and reinforces this point that you are making.
Randy, so like I'm making the point to you, if you have an investor and he wants to come and invest in this country, and he has any occasion to examine this report, question that we need to be asking is, how confident will that investor have in approaching any of our courts? That, for me, should be a great concern for all practitioners. It has nothing to do with MPP, NDC. My learned friend tried introducing that, it is because the NDC appears to talk down on the court system, and that is what has influenced the Mo Ibrahim Index. With the greatest respect, I mean, these international organizations appreciate the internal political dynamics. And so they appreciate what is called a bias in coming out with these indexes. If the conversation is only about NDC, they may think that, no, this is politics. But they have been speaking to investors. And those investors, what is the level of confidence that they have in how we adjudicate matters, especially matters involving the government? Randy, I'll give you a classic example. If you recall, there is this company called Imperial Heritage.
Yes.
Imperial Heritage, they're business people. They have obtained a judgment from a court. Now listen, this is a judgment that was obtained when evidence was taken. Evidence was taken. And the judge, after everything, evaluated the evidence and on merit ruled against the Republic. If the Republic has any misgiving, you appeal it. In a very extraordinary and novel manner, the Attorney General filed an application to set aside the judgment. One, that the filing fee or whatever that was paid did not commensurate with the claims. And some other issues. And the judge agreed. And on the basis of an application, set aside the judgment that he did upon review of the evidence. I mean, when you do things like this, you get an outcome. But you will be sending a different message across. Randy, so I am worried. Look, when H.E. John Dramani Mahama presented the election petition in 2020 to the court, one, when the defense was filed, the MPP, their first ground was that the petition should be dismissed because it discloses no cause of action. That was refused. So already the court acknowledged that the writ disclosed a cause of action. So you cannot sit here and say John Mahama presented something to court that was, if not, they won't put, when your people ask that the matter be dismissed because it did not disclose a cause of action, the court would have dismissed it. The mere fact that the court agreed and adjudicated evidence was taken is that the court found that there was the basis for coming to court. I have always maintained that we lost a glorious opportunity in refusing or disallowing the Electoral Commission chairperson to testify. Election adjudication is not a mere contractual rate that you come to court with. It is at the core of mandates. It's at the core of people's ability to determine through the ballot board who leads them. But we treated it as the usual contract, and A, B, C, D, and Madame will not, and this is, and it ended it. People are watching. And always remember that the people who are watching are equally sane and intelligent and are picking this. You see, where the impression is being created that anything that makes Akufo-Addo comfortable, the court will either delay it. That thing is fueling a very dangerous perception out there. That Akufo-Addo must be made to feel comfortable, pampered. It's a perception that is dangerous. And you see, Randy, why do I make this point? Immediately, MPs passed the LGBTQ law, the bill. The Constitution provides the mechanism if the president strongly feels that there are constitutional issues, the mode that he must go. That was ignored. And we saw the cease and desist letter from Mr. Bediatuo. If you recall, the president started raising issues about the bill when he met the diplomat at the time when there was no injunction application from Richard Delasky. How did the president know that Richard Delasky was going to go to court the next day? Because at the time when Mr. Akufo-Addo was speaking to the diplomats, there was no injunction application. How did he know? Was he the one who sponsored Richard Delasky to go to court?
Richard is not an MPP, by the way. I know him very well. He's a good friend. And I did my post call with him. Okay. In fact, he opposes MPP quite a lot. Okay. So I know Richard for sure.
I didn't say he's an MPP.
No,
I said
sponsor. Say that he's not.
No, sponsorship is different.
Well,
that's why I choose my word carefully.
Yes.
I am saying that when Mr. Akufo-Addo met the diplomats, was there any injunction when he was talking to the diplomats?
I don't know that.
How did he know that the next day Richard Delasky was going to court for an injunction? Was he briefed by someone? So you see, you people should not have the inclination that the people you are in the arena with, excuse my language, adapt. We see what is going on, and we appreciate what is going on.
They are not like me.
But you see, Randy, my friend, and again, look, Dom Levo. At the time the court eventually determined the matter, it had become Pyrrhic victory for Dom Levo. When citizens of the Republic, at the end of this kind of justice, it fueled the Mo Ibrahim report. Okay. Because you see, look at the speed, the alacrity with which this Afenyo-Markin matter had been determined. the same speed relative to Domilevo. Look at when the president came out with the Imposition of Restriction Act, one of the EIs, and my own professor of international law, Professor Tia, went to the court to challenge the constitutionality of those EIs, among other things. By the time the court gave its verdict,
too late.
There was nothing useful to do with that verdict.
Yeah.
Now, so when these things happen consistently, and the impression is created that Akufo-Addo is being pampered, that anything that makes him uncomfortable is either kept on the banner. How do you expect Domilevo? How do you expect that plaintiff to feel? Is there a different set of laws for Afenyo-Markin? Where there is a different set of law for other citizens of the Republic, it's painful. And that is why I have always maintained that we all do have collective responsibility in making the court system work.